Hey guys, this is the exclusive right to buy listing contract, and we'll go over what needs to be inputted. And yeah, okay. Exclusive right to buy listing contract. Buyer agency, we as Fathom are the buyer agency, or we're going to operate as a transaction brokerage. So select one of the two. This is an agreement between buyer and brokerage firm. Section 2, 2.1, we are a multi-person firm or a multiple person firm. Let's click on that. Define terms, Mr. Client. Let's update that. I'm using CTM. Brokerage firm, Fathom Realty, Colorado LLC. I am the broker. Property means a residential property that suits the buyer's needs. Okay. This can be pretty straightforward and vague, or it can be a certain address, whatever the buyer is looking for. Some buyers want to just go on one showing, then mark the address that you're going to represent that client for that showing. 3.5, we're going to look at the purchase. The listing period, 3.6, is going to start on a certain date, which is today, and continues through the earlier of one of the two, completion of the purchase of property or lease of the property. We are going to do a purchase, and I typically go out 6 months, but again, this is going to be between you and your buyer. This is the agreement that you're representing your buyer. So 1, 2, 3, 4, 5, 6, and I typically go to the end of the month. Let's do the 31st. Okay. Days and computation of period of days, deadline. So 3.8.2, computation of period of days, deadline, and computing a period of days when the ending date is not specified. The first day is excluded, and the last day is included. If any deadline falls on a Saturday, Sunday, or federal or Colorado state holiday, such deadline I always put will, but some like will not be extended to the next day that is not a Saturday, Sunday, or a holiday. Should neither box be checked, the deadline will not be extended. So don't have to mark it, but in good measure, I do. Section 4, brokerage relationship. 4.1, 4.2, 4.3, different brokers in company transaction. One broker, 4.3.1, buyer's agent. If you are going to represent your buyer and only as a buyer, if it's, for example, a family member or friend, close friend, and you're saying, hey, I'm never going to leave your side, mark buyer agency only. If it's, and I say this in regards to if maybe, let's say you have a listing and that your buyer likes the listing that you have, who are you going to represent? Your seller or your buyer? Or are you going to, yeah. So really the buyer agency only, I mark that if I'm working with close friends or family to state, hey, if you like listing of mine, I will represent you as your buyer's agent. Section 5 highlights all of your brokerage duties. Broker must exercise reasonable skill and care for buyer, including but not limited to the following. Okay. 5.1.1, performing the terms of any written or oral agreement with buyer, presenting all offers to and from buyer in a timely manner, regardless of whether buyer is already party to a contract for the purchase or lease of property. 5.1.3, disclosing to buyer adverse material facts actually known by you, the broker, advising buyer regarding the transaction, and advising buyer to obtain expert advice as to material matters about which broker knows, but the specifics of which are beyond the expertise of broker. 5.1.4, Stay in your lane. Always advise to get expert advice. 5.1.5, accounting in a timely manner for all money and property received. 5.16, keeping buyer fully informed regarding the transaction. 5.2, broker must not disclose the following information without informed consent of buyer. That buyer is willing to pay more than the purchase or lease price offered for the property. What buyer's motivating factors are. That buyer will agree to financing terms other than those offered, or any material information about buyer unless disclosure is required by law, or failure to disclose such information would constitute fraud or dishonest dealing. 5.3, buyer consents to broker's disclosure of buyer's confidential information to the supervising broker or designee for the purpose of proper supervision, provided such supervising broker or designee does not further disclose such information without consent of buyer or use such information to the detriment of buyer. Broker may show properties in which buyer is interested to other prospective buyers without breaching any duty or obligation to buyer. Broker is not prohibited from showing competing buyers the same property and from assisting competing buyers in attempting to purchase a particular property. Broker is not obligated to seek other properties while buyer is already a party to a contract for purchase or lease of property. Broker has no duty to conduct an independent inspection of the property for the benefit of buyer, and it has no duty to independently verify the accuracy of completeness of statements made by a seller or independent inspectors. Broker has no duty to conduct an independent investigation of buyer's financial condition or to verify the accuracy or completeness of any statement made by buyer. 5.7, broker must disclose to any prospective seller all adverse material facts actually known by broker, including but not limited to adverse material facts concerning buyer's financial ability to perform the terms of the transaction and whether buyer intends to occupy the property as a principal residence. 5.8, buyer understands that buyer is not liable for broker's acts or omissions that have not been approved, directed, or ratified by buyer. Know these duties as you enter and be confident in your duties and explaining those duties to your clients. Additional duties of buyer's agent. If buyer's agency box at the top of page 1 is checked, broker is buyer's agent with the following additional duties: promoting the interests of buyer with the utmost good faith, loyalty, and fidelity. 6.2, seeking a price in terms that are acceptable to buyer. And 6.3, counseling buyer as to any material defects or risks of a transaction that are actually known by broker. Okay, section 7, compensation of brokerage firm. 7.1.1 is the success fee. Brokerage firm will be paid as follows. 7.11 in a fee in the amount of a certain percentage. Again, this fee can go down but cannot go up after this is signed. Okay, so it can always come down if you're taking your buyer out, and let's say this starts at a certain percentage, and which this agreement states. You find a property, you contact the listing agent and say, hey, are you guys offering a buyer's agency compensation fee? And if that broker says yes, and that listing broker states the fee is lower than what is in this compensation of brokerage firm within the buyer agreement, this buyer agreement can be amended. Can only be amended down, not up. Okay. 7.1.1.2, adjusted amount. Let's see what Ambrose has for 7.1. Yeah, nothing there. Okay, getting back. So we are working with a purchase, and I don't have an hourly fee. I don't have a retainer fee. Other compensation, if you charge an admin fee, this would come here, and whatever amount is there. If you charge an admin fee, try and keep it the same for each transaction and trackable to where that admin fee is going. So if you use a transaction coordinator and that charge is 300, 400, 500, whatever the charge is, make sure that that's traceable. So if you do get asked about it and where that fee goes, that fee is being paid for admin purposes. Um, if it's going to go into your pocket, try and keep everything up here within this fee. Okay. If you're working leases, 7.2 would be it. When earned, again, that's lease. All right, 7.3, who will pay brokerage firm success fee? 7.3.1, seller's brokerage firm or seller may pay, buyer is obligated to pay. Buyer will pay. Okay. Um, if buyer will pay, buyer is obligated to pay brokerage firm success fee. Brokerage firm is not entitled to receive additional compensation, bonuses, or incentives from listing brokerage firm, seller, or any other source unless agreed to by buyer in writing. Okay. So I have a conversation, and I'm speaking on myself personally and how I run my business. 7.3.1 allows me to negotiate for the compensation. It also protects me in representation over that client, my client, if, for example, they find a for sale by owner property, and making sure that when I go to work, my fee that I charge for my services, the value that I have in my business, is paid. Again, this can always be amended. 7.4 is the holdover period. This is to protect you if you've shown your client any property. I've seen anywhere from 60 days to 90 days after the listing period expires, or let's say you get fired or you decide to quit working with that client. So within 90, so what this states is brokerage firm success fee applies to property contracted for during the listed period of this buyer listing contract or any extensions, and also applies to property contracted for or leased within X amount of days after the listing period expires. Holdover period 1, if the property is one on which broker negotiated, and 2, if broker submitted its address or other description in writing to buyer during the listing period. This is when this holdover period would be in place. So if you submit something via MLS, if you've taken your buyer on a showing, that falls within your holdover period. Okay. However, buyer will or will not owe the brokerage firm success fee and or under as indicated in compensation is earned by another brokerage firm acting pursuant to an exclusive agreement with buyer entered into during the holdover period. Any purchase or lease of this submitted property is consummated. If no box is checked in this 7.4, then buyer does not owe the brokerage firm success fee to brokerage firm. So what this states is if you take your client out, your buyer, you show them properties, and let's say you're not working for them anymore, all the properties you've submitted to that buyer are within your holdover period. If for whatever reason that buyer goes under contract with their new agent and it's still within this holdover period, you're stating that buyer will or will not owe the brokerage firm success fee. Okay. I've seen it either way, will or will not. Limitation on third-party compensation. Neither broker nor brokerage firm, except as set forth in Section 7, will accept compensation from any other person or entity in connection with the property without written consent of buyer. Additionally, neither broker nor brokerage firm is permitted to assess and receive markups or other compensation for services performed by any third party or affiliated business entity unless buyer signs a separate written consent for such services. We have an affiliated business arrangement disclosure, and this is where this comes into place. For example, Fathom owns a title company, a lending company, and an insurance company. We have to give notice to every client that we deal with which companies Fathom Realty, Fathom Holdings owns. Same thing stands for if you own another company that you have an affiliation with because of your ownership. That also needs to be stated within an affiliated business entity agreement or disclosure. Okay. Buyer's obligations to broker. Buyer agrees to conduct all negotiations for the property only through broker and to refer broker all communications received in any form from brokers, prospective sellers, or any other source during the term of this buyer listing contract. Buyer represents that buyer is or is not currently a party to any agreement with any other broker to represent or assist buyer in the location or purchase or lease of property. Buyer further represents that buyer has or has not received a list of any submitted property pursuant to a previous listing agreement to purchase or lease property with any other broker. One of these has to be marked. Okay. Default, right to cancel. If broker is in default, in the event the broker fails to substantially perform under this buyer listing contract, buyer has a right to cancel this buyer listing contract, including all rights of brokerage firm to damages. Any rights of buyer that accrued prior to cancellation will survive such cancellation. If buyer is in default, in the event the buyer fails to substantially perform under this buyer listing contract, including buyer's failure to reasonably cooperate with broker, brokerage firm may cancel this buyer listing contract upon written notice to buyer. Any rights of brokerage firm that accrued prior to cancellation will survive such cancellation to include brokerage firm's damages. Such damages may include, but are not limited to, the broker's out-of-pocket costs or the amount of compensation broker would have earned under Section 7. Cost of services or products obtained from outside sources. Brokers will not obtain or order products or services from outside sources unless buyer has agreed to pay for them promptly when due. For example, surveys, radon tests, soil tests, title reports, engineering studies, and property inspections. Neither broker nor brokerage firm is obligated to advance funds for buyer. Buyer must reimburse brokerage firm for payments made by a brokerage firm for such products or services authorized by buyer. Okay. Section 12, brokerage services showing properties. Okay. The following additional tasks will be performed by broker. If you have any special tasks that you are going to perform for your client, this is where you would enter them. Showing properties. Buyer acknowledges that broker has explained the possible methods used by listing brokers and sellers to show properties and the limitations, if any, on buyer and broker being able to access properties due to such methods. Brokers' limitations on assessing properties are as follows. And then this is where you'd put that reason in. Broker, through brokerage firm, has access to the following multiple listing services and property information services. So you are going to enter whatever MLS that you belong to. If you have multiple MLSs that you're a part of, this is where you would put that in. Section 13, disclosure of buyer's identity. Broker does or does not have buyer's permission to disclose buyer's identity to third parties without prior written consent of buyer. Typically, it's not a big deal if you're working with a celebrity or someone that wants to be under the radar, then that's where we'd put does not. Section 13, one of the two has to be filled out. Okay. Disclosure of settlement service costs, wire and other frauds. Again, wire and other frauds are rampant within the real estate industry. Removal of marketing material. Buyer acknowledges that marketing material used by the seller and the seller's broker, videos, photos, etc., may be difficult, if not impossible, to remove from syndicators and the internet, and releases broker from any liability for broker's inability to remove that information. Non-discrimination. Buyer understands and agrees that broker may not violate federal, state, or local fair housing laws. Make sure you know what those fair housing laws are. Recommend of legal and tax counsel. By signing this document, buyer acknowledges that broker has advised that this document has important legal consequences and has recommended consultation with legal or tax or other counsel before signing this buyer listing contract. Section 19, mediation. If a dispute arises relating to this buyer listing contract prior to or after closing and is not resolved, the parties must first proceed in good faith to submit the matter to mediation. Mediation is a process in which the parties meet with an impartial person who helps to resolve the dispute informally and confidentially. Mediators cannot impose binding decisions. The parties to the dispute must agree in writing before any settlement is binding. The parties will jointly appoint an acceptable mediator and will share equally in the cost of such mediation. The mediation, unless otherwise agreed, will terminate in the event the entire dispute is not resolved within 30 days of the date written notice requesting mediation is delivered by one party to the other at the other party's last known address. Section 20 talks about attorney's fees. In the event of any arbitration or litigation relating to this buyer listing contract, the arbitrator or court must award to the prevailing party all reasonable costs and expenses, including attorney and legal fees. Additional provisions. This is where you would put any additional provisions that pertain to how you do business or that you would like to put in with the buyer's agreement. Again, this buyer's agreement is how you work with your client and what you are going to be doing for your client. Typically, I see work hours, writing offers, showing, and when you're going to show homes. Yeah. Attachments. The following are part of the buyer listing contract. If you're going to have any other attachments, would be here. You can look at your docs list, which is there. You can put different clauses. I don't have any clauses within mine. No other party or intended beneficiaries. Nothing in this buyer listing contract is deemed to inure to the benefit of any other person or any person other than buyer, broker, and brokerage firm. Notice, delivery, and choice of law. Physical delivery notice. Any document or notice to brokerage firm or buyer must be in writing except as provided in 24.2 and is effective when physically received by such party or any individual named in this buyer listing contract to receive documents or notices for such party. We are typically on 24.2. There's not many contracts that are hand delivered these days or signed via ink, but it still happens. So that's why 24.1 is there. 24.2 talks about electronic notice. 24.3, electronic delivery. So, as an alternative to physical delivery, any notice may be delivered in electronic form to brokerage firm or buyer, or any individual named in this buyer listing contract to receive documents or notices for such party at the electronic address of recipient by fax, email, or whatever service you're using. Electronic delivery of documents and notice may be delivered by 1. Email at the email address of the recipient. 2. A link or access to a website or server provided the recipient receives the information necessary to access the documents. Or 3. Fax at the fax number of the recipient. 24.4 talks about choice of law. This buyer listing contract and all disputes arising hereunder are governed by and construed in accordance with the laws of the state of Colorado that would be applicable to Colorado residents who sign a contract in Colorado for real property located in Colorado. 25, modification of this contract. No subsequent modification of any of the terms of this buyer listing contract is valid, binding upon the parties, or enforceable unless in writing and signed by the parties. Counterparts. The buyer listing contract may be executed by each of the parties separately, and when so, executed by all the parties. Such copies taken together are deemed to be full and complete contract between the parties. Number 27, entire agreement. This agreement constitutes the entire contract between the parties, and any prior agreements, whether oral or written, have been merged and integrated into this buyer listing contract. 28, copy of contract. Buyer acknowledges receipt of a copy of this buyer listing contract signed by broker, including all attachments. And Section 29, Megan's Law, in the presence of a registered sex offender is a matter of concern to buyer. Buyer understands that buyer must contact local law enforcement officials regarding obtaining such information. Brokerage firm authorizes broker to execute this buyer listing contract on behalf of brokerage firm. All right, so Mr. Client is here. I would put in my email address for Mr. Client and brokerage firm, or broker's name, brokerage firm. If you don't have this section entered or don't have this information entered in this section, please make sure to fill this out as quickly as possible. We're going to remove all NAs and we're going to replace with none. It's been something that I've used and have just started to be in good habit of. And that is the exclusive right to buy listing contract. One thing I did want to say about the exclusive right to buy listing contract is that the signature date of Mr. Client, or whoever your client is, needs to be the same day or prior to your contract date, and needs to be the same date as your definitions working relationships. Okay.